Major breaking news out of the United States Supreme Court. A huge petition for cert has just been filed in the U.S. Supreme Court, sponsored by the Second Amendment Foundation and the Firearms Policy Coalition, including several other plaintiffs, arguing that the flat ban on ordinary citizens carrying firearms on public transportation in the state of Illinois is unconstitutional under the Second Amendment. What are their arguments and what are the chances of the Supreme Court granting cert in the sensitive places case? Stick around and we'll explain it all to you when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so before we talk about the Schoenthal case out there in the United States Supreme Court, arising out of the 7th Circuit in Chicago and Illinois, I just want to remind you all that this Thursday at 2 p.m. at the National Lawyers Convention of the Federalist Society, I will be giving a major presentation about the Second Amendment, talking to a room full of law clerks, to lawyers, to influencers, to scholars, to judges, and so on. The good news is you'll be able to pick that up on YouTube 2 p.m. on this Thursday out of Washington, D.C. And if you miss it there, I'll try to repost it here on my channel over the weekend after I give the presentation. It's going to be a big one. I'll try to give you a preview between now and Thursday, but just a heads up. And if you're at the Federalist Society Conference, make sure you stop by and say hello Thursday at 2 p.m. All right, folks, so here we are at the United States Supreme Court. The Second Amendment Foundation and the Firearms Policy Coalition have filed a joint petition along with many plaintiffs here in a quote-unquote sensitive places case. The phrase sensitive places is really a euphemism for government-mandated gun-free zones. Now, as you know, the Supreme Court in Bruin and in Heller made references to the fact that there are on occasion, or at least there can be on occasion, so-called sensitive places that are consistent with text and the history of the United States Constitution, specifically the Second Amendment. Well, in this case, the Schoenthal versus Rao, a case out there in the state of Illinois, the federal district court judge out there found that the Illinois state flat prohibition, flat ban on ordinary Americans carrying firearms on public transportation violated the Second Amendment. Obviously, this makes a lot of sense, and we'll get to that in a second. Of course, that was appealed to the United States Court of Appeals for the 7th Circuit, which on balance is generally terrible. Unless your name is Michael Brennan, you're generally a terrible judge when it comes to guns on the 7th Circuit. Prove me wrong on that. Nevertheless, the 7th Circuit basically said, no can do. We disagree with the district court. They had a crazy, haphazard, totally varied, inconsistent, confusing opinion, just throwing darts against the dartboard blindly to justify and uphold this ban on carrying guns in public transportation in the state of Illinois. Going so far, believe it or not, to even cite to late 19th century private railroad rules, which in addition to being the absolute wrong time period, because why on earth, with the late 19th century, the era of the industrialization, the era of the so-called robber barons, what do you want to call them? Why on earth would Americans at that time have everything to say about the meaning of the Second Amendment and what it was understood to have codified, reaffirmed, in the year of our Lord 1791? Obviously the wrong time period, but beyond that, the 7th Circuit actually embraced private rules. And what's the problem with that, folks? Well, you know that the United States Constitution is all about limiting government conduct. The Second Amendment applies to prohibit governments, state governments, local governments, federal governments from misbehaving and violating our rights. It doesn't govern private behavior. Nevertheless, the 7th Circuit went so far to use private regulations involving commercial railroads to justify a government regulation using not only the wrong time period in the late 19th century, but also not even using laws. Because remember, under the Bruin methodology, which is really the Heller methodology dumbed down for the inferior court judges, you start with the text of the Second Amendment, then you shift the burden to the extent that the government's conduct implicates the text of the Second Amendment. If it does, the burden shifts to the government to show a historical tradition of firearms regulation. Well, that historical tradition of firearms regulation refers to laws and statutes and constitutions and other government conduct. Has nothing to do with private railroads did or did not do in the late 19th century. Nevertheless, the Seventh Circuit went so far to actually use private rules to justify a government historical tradition of government regulations. Totally wrong. So nevertheless, here in the Schoenthal case, the Second Amendment Foundation, the Firearms Policy Coalition have now sought cert in the United States Supreme Court, saying basically, look, Supreme Court, you made references to the sensitive places doctrine in Heller. You made references to it in Bruin. You identified 3 sensitive places in your view. Legislative chambers, like Congress, courthouses, and polling places that at the time of the founding were so-called sensitive places. That's all the Supreme Court said. And then the lower courts, of course, have gone around and justified all these sensitive place laws, which again are government-mandated gun-free zones, all flying in the face of many historical traditions of allowing, in many instances requiring, Americans to bring firearms into places that were vulnerable, where vulnerable people were. In fact, this powerful brief in the Schoenthal case, this powerful brief by the Second Amendment Foundation and the Firearms Policy Coalition makes exactly that point. That at the time of the founding in the 18th century, there were many laws that required Americans to bring their firearms with them to protect the local population, such as at church, where the Native American population, i.e. the Indians, were always at risk of coming in and scalping people. Did they say no tomahawks allowed? Did they say no clubs allowed? No. They required people or encouraged people to bring firearms in the event that they were attacked by the Indians. Nevertheless, here you have these states, the terrible states, of course, being upheld by these anti-gun courts or courts that seem to be confused about what is a sensitive place. Well, this brief does a very good job pointing out that the lower courts are all over the map as to what is a sensitive place. And there's really only one answer. And let me step back briefly and explain this to you. I've done it in prior videos, but we're going to do it here. The only way you can come up with a principled defense of the sensitive places doctrine, in my view, is that you have to account and include in sensitive places the 3 places at the time of the founding the Supreme Court has identified: the legislative chambers like Congress, the courthouses, and the polling places. And at the same time, you have to account for what the Supreme Court undeniably will allow to be a sensitive place if a legislature enacts such a law, which is you cannot have guns at nuclear power plants and you cannot have guns at TSA. So the question is, what historical tradition of firearms regulation in the 18th century that justified banning guns among ordinary Americans in polling places, in legislative chambers, and in courthouses in the 18th century is also consistent with today in the 21st century, let's say, a law that bans private firearms at nuclear power plants and also, of course, at TSA. And there's really only one theory out there that accounts for all this. There's only one principal doctrine that accounts for all of this, and that is the comprehensive security doctrine, which makes a lot of sense, which is this. If the government wants to disarm you, if the government wants to disarm me, if the government wants to disarm us in a particular place, guess what? They can do it if and only if they step up and provide the full-blown comprehensive security and armed security that means that we don't need to bring our own guns because they're going to do the job for us. Keep in mind, in the Bruin case specifically, the U.S. Supreme Court said that it would not be legal and constitutional under the Second Amendment to say that the island of Manhattan, remember, New York City has 5 boroughs. The most important one by far is Manhattan. It's an island. The Supreme Court said in Bruin that you cannot ban guns in Manhattan just because there's cops around and there's a lot of people around. So these various doctrines thrown out by the anti-gunners that there's vulnerable people there. There are too many people there. It's congested. There are cops or whatever this is. None of this flies historically except comprehensive security, which means if the government wants to take my gun away, if they want to take your gun away and say, don't bring your guns into this particular place, it's a sensitive place, they must protect us from the bad guy. And today, in the 21st century, that requires metal detectors and armed security. We know that being congested does not mean anything with the sensitive places doctrine, because the Supreme Court specifically said that just because Manhattan is congested and there's presumably law enforcement floating around in the form of NYPD, that is not enough to make it a sensitive place. In fact, if you look at the 18th century, specifically the oral argument made at trial by the prominent Boston attorney John Adams, one of our founding fathers, prominent Boston lawyer, John Adams literally said at trial of the British officers who had fired upon and committed a mass killing of American patriots during the Boston Massacre. John Adams, the attorney on behalf of the British, said, "We admit and acknowledge that in America, the American patriots had every single right to be in that most popular, congested part of Boston at the time with arms." But his argument was that, yes, they were allowed to have arms, but they had to use those arms peaceably. They could not violently threaten, illegally and unjustifiably, my British soldier clients. That was John Adams' argument, literally admitting that in the most congested, busy, popular part of downtown Boston in the 18th century, he acknowledged that the American colonists in that city, at that place, were totally allowed to have their own arms. So you cannot say today, while applying the Second Amendment, that being a congested place with a lot of people, like a subway, like a bus, somehow you can ban guns, because you could not do it at the time of the founding, as John Adams admitted. Beyond that, again, as I just pointed out earlier, vulnerable people at the time of the founding, if there were vulnerable people, if there were vulnerable settings, if there's a real risk of an attack by bad people, such as the Indians that wanted to scalp you, what did the founding fathers do? They required you, or not only allowed you, they in many instances encouraged you or required you to bring guns. So again, just because they're supposed vulnerable people doesn't serve as a historical basis for taking away the right to keep and bear arms in a particular place. And of course, the one thing that does make sense, if you look at the historical record, which is in a very impressive, comprehensive historical record, and I'll link the brief down below, you should take a look at it. At the time of the founding, the Firearms Policy Coalition and the Second Amendment Foundation have pointed out in detailed historical fact in this brief that if you look at polling places at the time of the founding, they were protected by armed sheriffs and armed sheriff's deputies. If you look at legislative chambers at the time of the founding, they were protected by the sergeant of arms. If you look at courthouses at the time, they were protected by the bailiffs. In fact, this brief goes back and shows that even in jolly old England, from which we drew quite a bit of law here in America, if you look at Parliament as well at the time in the founding and beforehand was protected by men with arms. The point is the historical tradition here in the 18th century shows that if you want to declare a place sensitive and ban Mark and you and Bob and Billy Bob and George and Tom from having guns, you can do that, but you've got to provide the armed security. And today, in light of the ubiquity of handguns, I would argue that requires metal detectors. Because at the time of the founding, you didn't have metal detectors, and you didn't really need them because most people were bringing long guns anyway, and you could see them. Today, because everyone, as Heller indicates, is bringing handguns, not only would you have to provide armed security, in my view, to have comprehensive security, you also have to provide metal detectors. Because, again, people bring handguns, and that's the only way to make sure that there's no guns in that place. Because that's the key. You can't put up a sign that says no guns allowed and then allow guns in that place, because you're allowing, as Cesar Beccaria pointed out, and I have to note here, this brief actually cites to a very handsome YouTuber that you all know and love, Mark Smith. They actually cite to an important article I wrote many years ago about Cesar Beccaria, who was an Italian criminologist who Thomas Jefferson and John Adams absolutely loved. The founding fathers at the time of the founding looked very seriously at the historical work and the written criminological work of Cesar Beccaria. And one of his critical points was literally that if you pass laws that disarm ordinary people, all you do is make them more at risk. You put their lives into danger because criminals do not respect laws that ban guns. That is not a 21st century NRA slogan. That is literally from the 18th century criminologist Cesar Beccaria, who was such an important figure that his works and his books were at the Constitutional Convention, I believe, and was read by John Adams and Thomas Jefferson as they wrote the Constitution, and of course involved themselves with, among other things, the Second Amendment. And I'm happy to report that my scholarly research found its way into this brief. The point is, throughout history, if you want to ban guns, then the government has to step up and provide the guns to defend you. If they're unwilling to provide those resources and devote those resources to protect you and your family, they cannot declare something a sensitive place. That is the historical principle. And I can assure you that when the government wants to make a place a gun-free zone, such as federal courts, the Supreme Court, the Congress, they know exactly how to do it. When I was, when I go to the Department of Justice, when I go to the Congress, when I go to these places over the years, I can assure you, you cannot walk in there with a gun because they have metal detectors, they have all sorts of checks, they have guard dogs, they have men with guns, and so on and so on. We've all been to courthouses, we've all been to these places, and again, the key is they have to make sure the bad guys cannot bring guns into those places. And as the Bruin oral argument pointed out, as there was a discussion during the Bruin argument itself, at argument, there was literally a discussion about the fact that even though guns are banned on New York City subways, everyone understood, including the Attorney General for the state of New York that argued the case, that of course illegal guns were getting onto the subway by the criminals. Which means you and I really need to have guns there more than anywhere else because the criminals are bringing the guns into places like the subways, they're bringing it into the trains, they're bringing it onto the buses, and unless you have metal detectors and armed security there, you have to be your own first responder. And that is essentially what this powerful brief in the Schoenthal case has to say in this petition for cert against the state of Illinois, and we'll see what the Supreme Court does. Will the Supreme Court grant cert? They might grant cert on this case. It would be a very nice companion case to the Wolford case, which is the default no carry rule out of Hawaii. Certainly, if they granted cert in the Schoenthal case, they've already granted cert in the Wolford case, again, which is the no carry default rule. That would be a very good set of cases to really lay out and flesh out the law of so-called sensitive places and what it means under the Second Amendment and what is allowed and what is not allowed. And in my view, comprehensive security is the best historical tradition. It accounts for, again, banning guns on planes because TSA is metal detectors and armed guards. And it also accounts for the historical record, which this argument by the Schoenthal plaintiffs did a very nice job in their petition. I encourage you to read the brief, which I will put a link to down below. All right, folks, there you have it. Hope you enjoyed today's episode. Make sure you follow me over there on X at @ForBoxingDiner. Don't forget to subscribe both to YouTube and to Rumble, and I look forward to talking to you all again real soon here at the War Boxers Diner.
Orders up. Table 2A.